And the new rules address the delays in various formats. One, you have to deal with issues when parties challenge the jurisdiction of the tribunal. As many of us know, someone who does not want to go ahead and arbitrate immediately goes and said, I didn't sign the agreement, or the agreement is invalid for a reason, or the dispute goes beyond the scope of the arbitration agreement. Well, if you go ahead and challenge that's going to delay the proceeding. The new rules, and so there's rules that deal with that, and we'll be discussing that. The new rules also require, and we'll be saying that the arbitrations be conducted efficiently. One thing is, you would think that everyone wants to be conducted efficiently, but now that forms part of the rules, and there are sanctions that go ahead and enforce that mandate. The new rules also force an arbitrator to consider the best evidentiary methods suited for a case very early on in the process. That way, forcing the early involvement of the arbitrator. Part of this is through a case management conference, which is something that you would think traditionally happens, but sometimes didn't. And then the new rules include a new appendix that suggests techniques for managing arbitrations efficiently. So I'm going to address the three new concepts to improve time and costs in arbitration. These three concepts are the following: new screening procedures for jurisdictional challenges to arbitrations, talks about the new articles dealing with the new case management provisions, and the new enforcement provisions. The challenges under old challenges under Rule 6.2 have been increasing dramatically. And the Secretariat studied this, and it saw that up to 30% of all cases had jurisdictional challenges. Well, what would that mean? That means that the Court of International Arbitration, the would have to consider that challenge, because 98% of those things were frivolous. The court would reject the challenge and send it to a tribunal, which would then go ahead and consider the challenge anew. Thus, the parties would have to litigate the issue of jurisdiction twice, making it that much more expensive. Now, what kinds of jurisdictional challenges are there in ICC proceedings? First, you have those that say that for legal reasons, the arbitration agreement is void. The ICC considers that to be best resolved by the arbitral tribunal. To give you an example, I recently had an arbitration against Venezuela, the government of Venezuela, and Venezuela was saying, well, under its own laws, that arbitration clause was null and void. Well, if it's a legal issue, the tribunal should really decide that. However, there are times that, let's say, someone never signed an arbitration agreement, and then the ICC feels that that would be unjust to force someone who never signed an arbitration agreement and clearly is not part of an arbitration agreement to incur the cost and time of defending this in front of a tribunal. That is left to the ICC court itself. I'm now being told that my time is wrapping up, so I'm going to try to go quickly. The manner in which the ICC dealt with this is by the new Article 6.3, where the Secretary General goes ahead and looks at the claim of jurisdiction and says, is this frivolous? Well, then I'm going to send it to the tribunal. Is it frivolous, or is it something that is best suited for the tribunal? And it's going to send it. Only in the very small number of cases where it really feels that the court should deal with that, will it go to the court, and that That way, that will speed up the process. The ICC also included provisions for new case management. This contemplates that each arbitration is to be tailor-made for each specific dispute. This is included in Article 22 of the new provisions. And as I said earlier, if you see here, Section 1, it creates a contractual obligation to be expeditious. It says the arbitration tribunal and the parties shall make every effort to conduct the arbitration in an expeditious and cost-effective manner. This is a best efforts provision. But as we're going to see later, there's teeth behind this. Then, under Article 24, you have to go ahead and have a case management conference. Immediately after the terms of reference, you have to go ahead and have a case management conference where the tribunal is to study the case early on, look at the case management techniques, enter a procedural timetable. Case management conference can be done by telephone or video conference, but very important, the tribunal can demand that a client be part of this procedure. That way, clients are involved, and then when lawyers go ahead and make decisions, the client can say, yes, I agree with that decision, or no, I think it's not going to be a cost-effective manner in which to do things. So you would go ahead, the chronology is the tribunal would call for a case management conference, they would look at the techniques in Appendix 4, the terms of reference are drafted, the case management conference is conducted immediately, and a procedural order is issued. And then I want to end up talking about the new enforcement provisions, because this is very important. If you look under Section 5 of Article 22, the parties have to comply with the tribunal's orders. But here's where there's teeth behind all of this. Article 37.5 allows the tribunal, when it makes a cost determination at the very end of the case, to take into account whether a party conducted the arbitration in an expeditious and effective manner. So the tribunal can say, I found that this party was obstreperous, was trying to delay the proceedings, he just didn't want to go through it, and it increased the costs. It can take into account. But it doesn't end there. Under Appendix 3, the ICC can also hold arbitrators to account. And if you look at Appendix 3, Article 2, I set out the text right there. It says, in setting the arbitrator's fees, the court shall take into consideration the diligence and efficiency of the arbitrator. So this is something that, as time goes on, and as the ICC continually sees that if an arbitrator is not issuing orders on a timely basis, and it's not conducting things on a timely basis, it can reduce the fees that it would be entitled to under the cost schedule of the ICC. So, Hannah, if I went too long, I apologize. And if there's any questions, of course, at the end of the webinar, I'll be glad to answer them.
Sure. Thank you very much, Louis. 루이스 변호사님 감사합니다. 다음은 브라이언 홉킨스 이사님을 모시겠습니다. 브라이언 이사님은 미국 삼성전자 법무팀 상무로 10년간 근무했으며 20년 동안 해외 소송을 관리 감독했습니다. 또 US Court of Arbitration의 임원이셨습니다. 예, 그럼 이사님의 말씀을 들어보겠습니다. Hi, Brian. It's all yours.
Oh, thank you very much. Are you handing over control of this to me? Let's see.
Yes, I am. Just one moment, please.
Okay.
You should have it. Bryan?
Yeah. Well, thank you very much.
You have...
Okay. I'm Bryan Hopkins. I'm a director at Ju앤합킨스, and I really want to talk today about controlling your litigation costs with regards to litigating in the United States with an emphasis on e-discovery. The fact is, e-discovery has become a very important and vital issue in litigation involving U.S. companies or involving litigation in the United States, primarily because of the changes in the federal rules of civil procedure and the case law. Some reports estimate that approximately 80% of costs of litigation in the United States actually relate to discovery, which is astounding and can be quite expensive. So cross-border litigation involving cases in the U.S. involving e-discovery issues are very costly. And as the DuPont versus Colon case shows, failure to have an adequate e-discovery plan in place and failure to adequately address e-discovery issues and processes not only are costly but really can be fatal. So what do we do and how do we control these costs? And I want to talk a little bit about that today. So what happened? Well, the U.S. Civil Rules of Procedure made a few changes, especially with the discovery rules. And the discovery rules recognize the party's right to seek electronically stored information, mandates disclosure of electronically stored information, ESI, including location of it, and allows the requesting party to really specify the forms of production. So with the rules that have been changed, such as Rule 16 and 26 and 34, it is now incumbent upon companies that are involved in litigation or will be involved in U.S. litigation to really address what to do with e-discovery and how to handle it. What's the issue? Well, the issue is, over the last few years, e-discovery or the platforms and technologies involving electronically stored information have just exploded. A year or so ago, it was estimated that approximately 60 billion emails are exchanged every day with no regards to their content. Perhaps today it's more like 80 billion or 100 billion. We have instant messaging. We have new technologies and storage processes that now make finding and handling electronically stored information very complicated. In fact, the IT departments of many companies don't understand everything and may not even find everything or know where everything is located at. The stakes are high. Besides the Colon case, another famous case, of course, is the Morgan Stanley case. In that case, there was a $1.45 billion verdict against Morgan Stanley because of electronically stored information, mistakes, and ESI discovery abuses. So obviously, having the right plan and addressing